Good morning. May it please the court. My name is Sarah Pellenbarg. I represent the appellants, Dr. Steeple and Patel in this matter, and I would like to reserve 5 minutes for rebuttal.
Sure.
There are two issues in this case today. The first is whether the trial court abused its discretion in granting enlargement of time with regard to the Nanagams motion for attorney's fees. The second issue is whether the Nanagams have a substantive right to attorney's fees under section 44103(6), which is an arbitration statute which allows a trial court to award attorney's fees if a party goes through arbitration, elects for a trial de novo, and then recovers 25% less in the trial de novo than in the arbitration. In our case, the parties recovered 0 in the arbitration and 0 at the trial de novo. This issue has been decided against us in a prior related case. It is pending rehearing and rehearing en banc, and thus the issue is still alive, and we're hopeful it will be resolved in our favor and be dispositive in this case. The first issue, however, is whether the trial court abused its discretion in granting enlargement of time. Now, Rule 1.090 states that if the time period has expired for filing a particular motion, a party may seek enlargement of time, and a court may grant enlargement of time if that party demonstrates excusable neglect. The courts have pretty unanimously held there's parameters in defining what constitutes excusable neglect. On the one hand, an operational error will constitute excusable neglect. That's a mechanical or operational breakdown in the practices and procedures of the law firm, usually in the staff or the equipment. On the other side of the spectrum, an attorney error, mistake, general inadvertence, that sort of situation where the attorney just makes a mistake does not constitute excusable neglect.
Tell me this, can you separate the attorney's failure to give the direction which then triggers the operation from a true operational error? Because it seems to me that the cases speak in terms of there are instances where support staff basically fail to tickle a timeline.
Right. Typically it is the staff that make the mistake. We're actually
But it's the attorney that has to direct the staff.
Right. And there's really no evidence of the operational practices that were really even in place in this situation. I mean, for one attorney to say the other thought he was calendaring the deadline, the other attorney to say, you know, the former thought she was calendaring the deadline. I mean, what are the operational practices that are employed by the law firm, and why and how did they break down? And we haven't really been told that here.
Was there an objection to the failure to put forth that evidence below?
There was not. There was not. However, although that would be immediate grounds for reversal under the law, I still think it's a factor that you can consider. It's a fact that the court weighed, the fact that there was no affidavits presented, and it just was a few casual hearing involving the attorneys just testifying. The problem here, however, and the real problem, is that we're willing to assume that there was an operational error. We're willing to assume that one attorney thought the other thought she was calendaring the deadline and vice versa. The problem is the timeline doesn't support this argument. What happens is on February 6th, the judgment's issued. Fast forward to March 25th, they're 17 days late at this point, and that's when they filed their motion for fees. Fine, an operational error occurred and they missed the deadline, but at some point one of them should have had this aha moment, we're late, we've got to get this motion out. So they both admit that they participate in drafting this motion. They reference the February 6th judgment in the motion. They sign the certificate of service, and they send it out without confirming whether it's timely or not. That's not an operational error there, that's a mistake. And that's where the operational error, if there was one, transformed into an attorney mistake. Because then we wait another month. We get to the hearing, we're now 3 months after final judgment. We get to the hearing, and we file our opposition motion to their motion for fees. We cite Rule 1.525. We cite the Florida Supreme Court cases which say this is a strict bright line time requirement. We cite the Second District Court of Appeals cases which confirm that it's a bright line time requirement. We cite a case that suggests a motion for fees which is 1 day late will be denied. We cite all this law, and of course they show up at the hearing and then say, well, you know what, you're right, there's a problem, so we're going to cancel the hearing and we're going to file an enlargement of time. And then a week later we get their enlargement of time. This is not proper under the rule. If you look at the case law, Sayamoto Freight Line case, that's the Florida Supreme Court case out of 2006, that court actually holds that a party can, in fact, file a motion for enlargement of time in connection with a motion for attorney's fees. And it cites the South Trust Bank case, State versus South Trust Bank, out of the First District Court of Appeals favorably. And it says, under circumstances like this, you can file for an enlargement of time. Well, what happened in that case? The secretary made a mistake calendaring the deadline. When she discovered the deadline, she immediately filed her motion for enlargement of time alongside her motion for attorney's fees. That didn't happen here. This long delay in waiting between the time you file your motion for attorney's fees and the time you file your enlargement of time is not proper, because there's just no excuse. As an attorney who's aware of the rules, who's aware of the fact that 1.525 is a very strict rule, they admit being aware of this rule, there's no excuse when you send that motion off to not confirm that it's timely.
So to summarize, your position is the motion is filed late, but it's not referenced as being late. There's no
Correct.
explanation as to why it's late. There's no affidavits. There's no motion for enlargement. There's just a late motion.
It's just a late motion with nothing else. And it was only when
the
we...
explanation comes later when you point out, your side points out, well, this is a late motion.
Exactly. And of course, there has been a lot of recent Florida Supreme Court law on this issue, and it is a bright line test. Everyone knows that it's a bright line test. They say they know it's a bright line test. So given the context and the backdrop of Rule 1.525 and the goals that the Supreme Court is trying to effectuate in repeatedly holding this is a bright line test, and the courts that have said 1 day late, you're out, I'm sorry, this would completely circumvent that rule to allow a party to casually request enlargement of time at the 11th hour after they've been alerted to a problem by opposing counsel. It's improper, and under these circumstances, we do believe it was an abuse of discretion for the trial court to grant enlargement.
Do you believe that this Saia case is your best case?
It's one of the cases that suggests this is a strict bright line time requirement. The Ameris Life case takes that to the next level and confirms it's a bright line time requirement. In terms of the cases that suggest that inadvertence and ignorance of the rule and general mistake is not worthy of a finding of excusable neglect, I think the Spencer versus Barrow case out of this court in 2000 is a good example of that. But generally, yes, Saia, because it cites the South Trust Bank case and it provides an example of how an enlargement of time is done right, I think that that's probably our best case. There's really not a case that provides this exact example, and that's because there shouldn't be a case on this example, because the Rule 1.525 has such stringent time requirements which have been developed so recently that there's really not as much law addressing enlargement of time in connection with 1.525. So for these reasons, we do believe that the trial court abused its discretion in this case. Now, the second argument, if I may, is I'd like to argue essentially a rehearing motion from the prior case and catch your attention. I'm in a unique procedural situation. This is at issue in this case. The prior Second DCA panel, 2 of the 3 judges sided with opposing counsel, and it affects not only us, but it has wide-ranging effects, and it's very important that we attempt to correct it now. Again, Section 44.1036 allows a trial court to award fees if a party goes through the arbitration process, elects for a trial de novo, and does 25% worse in the trial de novo. So not 15% not worse, not 20% worse, but 25% worse. There's a clear directive from the legislature. This is a sanction here. Normally you're not entitled to fees. This is a sanction, and because it's a sanction, it's strictly construed. Now, what the other side did is they were able to convince the prior DCA panel to apply what is known as the absurdity doctrine. What is the absurdity doctrine? The absurdity doctrine provides that if you're applying the literal language of the legislative statute and it creates an absurd result, then you don't need to apply the literal language of the statute. Well, this is not a casual rule that the court can apply whenever they disagree with a policy. I'd like to read to you from the Florida Supreme Court. This is cited in our motion for rehearing that you did take judicial notice of. The State versus Hackley decision. This is a Florida Supreme Court 2012 opinion. But the absurdity doctrine is not to be used as a freewheeling tool for courts to second-guess and supplant the policy judgments made by the legislature. It has long been recognized that the absurdity doctrine is to be applied to override the literal terms of a statute only under rare and exceptional circumstances. And that's particularly true in a statute that's strictly construed because it's a penalty. Now,
well, it's strictly, and if the statute did not exist, there would be no right to fees.
Exactly. Now, I guess what I struggled with and what I was trying to figure out is what does it mean for something to be absurd? I mean, what does that really mean? And in our rehearing motion, we cite an article out of Harvard Law Review that has essentially examined this doctrine across the entire country. And what they equate it to is essentially a constitutional rational basis test. Is there any legitimate basis on which the legislature could have intended the literal language of the statute to apply to create these results? And I think Judge Altenberg picked that up in his dissent when he said, there is a reason. Maybe this arbitration process is extremely casual. And they've recently changed the statute when they added this 25% difference. They made this process more casual. So you don't necessarily get to present evidence. They say evidence is kept to a minimal. You certainly don't go before a jury. It's a very casual process. So if you don't recover from this process, there's no evidence that the legislature intended to sanction you for fees moving forward. And just to kind of put this into more of a concrete example, in this case, the arbitrator found that the Nandigans acted in bad faith, and that was his finding. But he said, I don't see that I can give you any money. So in this situation, the Patels are forced to pay the entire note and mortgage on this building that both parties bought, both parties signed guarantee agreements on. That's essentially the effect of the arbitrator's ruling in rejecting essentially their arguments and their complaint. So is it so clear that in this situation the legislature intended to sanction them with the other side's attorney's fees moving forward and electing for that jury process and the protections of the evidence code and the things that we've come to appreciate in the trial process? And there's no evidence they did that. And just outside of this case, and the reason why this case is so important to plaintiffs in general, is little guys don't have deep pockets and unlimited pockets to pay, corporate attorneys on the other side who may be $500 an hour. So if you're sent to arbitration, and you can be sent against your will, you're participating in this casual process. For the Patels, it was just a quick afternoon. You happen to lose. For some reason, the protections of arbitration don't grant you any results in the case. You don't get positive results in the case. Is it so clear that the legislature intended to sanction these people with the threat of attorney's fees, of paying the other side's attorney's fees for electing for a trial de novo? There's no evidence of that. And normal people will not be able to afford to go forward with the trial process and with the threat of attorney's fees on the other side hanging over their heads. And because there's no evidence of this, because the statute is strictly construed, because the court misapplied the absurdity doctrine in the prior case, we respectfully request that you either participate in this case en banc or perhaps speak with Judge Sleet or Davis and help them change their mind. So for these reasons, we believe there's no substantive...
Go en banc.
We believe there's no substantive basis to attorney's fees in this case, and that because they filed their motion out of time and their enlargement of time was not justified, they're not entitled to fees. Thank you.
Thank you.
May it please the court. Your Honor, Douglas Zabo representing the appellees, Drs. Bala and Usha Nandigam. Let me address the second issue because I think it's probably the easier issue, and that's the issue with regard to the statute in Chapter 44. Counsel stated that it was a casual process and that they were just there for an afternoon. I was there. I was the counsel handling it. The Patels sued my clients in a consolidated arbitration, 2 separate lawsuits, and sought over $2.5 million from my clients in that process. There was nothing casual or arbitrary about it. We were there for a full day in that case, and I would submit that the Judge Davis and Judge Sleet got it exactly right in this case. The sole purpose of the Statute 44 is to put sanctions on somebody, to have repercussions in situations where somebody gets an adverse verdict at a non-binding arbitration and then proceeds to go to trial.
And do 25% less. That's what the statute said.
Understood what the statute says.
And the legislature is deemed to know the rules of statutory construction. It's, long, in this case, the statutory provisions for attorney's fees are strictly construed. And the legislature had to know that. How do we possibly get around that?
Because of the reasoning set forth in the opinion written by Judge Davis. The worst possible result, or turn it around, the best possible result I could get for my clients in this case was a 0 verdict at arbitration and then a 0 verdict at trial.
And the statute does not say you get rewarded with fees for that.
Which is exactly the provision that we cited in our prior brief that was relied upon by Judge Davis, the Supreme Court decision in that case that said you can ignore it if it is an absurd result.
But
In that case,
and Judge Altenburn in a dissent has suggested a reason why it's not absurd.
and let me explain to you with all due respect to Judge Altenburn why that doesn't make sense. He gives an example and says that in the situation where somebody sues for $30,000 and gets a verdict at non-binding arbitration for $20,000, that the person, could be the little person, the little guy in that case, is then forced to decide, listen, $20,000 is a lot of money, I better decide what to do because there's sanctions against me if I proceed. In this case, in the case that we were talking about, 2707 was the underlying case, the one that went up on appeal, they sued for over $1.5 million. That was the substantive amount. There was going to be prejudgment interest on that and attorney's fees on top of that. Do you think for a second that if they had gotten a substantive award of, say, $20,000, that they were going to accept that? If the arbitrator, and here's the
problem. You are suggesting that we should apply a construction to the statute based on the specific circumstances of your client. And Judge Altenburn, in his dissent in the other case, suggested an alternative scenario, and it's the same statute.
He suggested in every single scenario, except one, I would get fees. If the arbitrator had awarded $1, if he had awarded a quarter, so the only, and this is why it's absurd, every single scenario that's possible from now to infinity, any dollar amount, pick it. Pick any amount of cents, any amount of dollars. In every single scenario, if he had awarded 1 penny, 0 is 25% less than 1 cent, I would have obtained fees. That's what makes it absurd. That's why the legislature could not have intended that result.
If he had ordered a nickel, maybe the Patels would have reconsidered whether to go forward. But I don't see how we can run through these scenarios and find some in which it would seem unfair and some in which it would seem fair and declare that it was absurd for the legislature to word the statute the way it did.
Because with all due respect, Your Honor, the only scenario that's unfair is when you get the best possible result. If I do the best possible job for my client at arbitration and I prove beyond whatever standard, preponderance of the evidence, reasonable doubt, whatever the standard is, I prove that you have no case. It's the most frivolous of all cases. You're entitled to no damages. And if you read the opinion that came out, it's a 17-page scathing opinion written by Judge Richards, the trial judge, saying that in fact the theories that they sued upon, that we were trying to force them out of the business, was in actuality what he was trying to do. He was trying to force my clients out, that he came up with this scheme. So in that scenario, when I get the best possible result and I prove that to the non-binding arbitrator, I'm left and they have the option to just roll the dice. They have no repercussions whatsoever.
And if there was no statute, you would be in the same position.
If there was no statute...
No statute such as this, you would be in the same position because we're under the American rule.
Understood.
No
That would be the position, but there is a statute.
There
And
is
so
a statute
therefore,
that-
are you willing to...
Excuse me, there is a statute that says what it says. And so, if we say, well, it's absurd for the statute to say this, but so if the statute didn't exist, you would still get nothing. I don't see...
I understand that, but that's why the absurdity doctrine exists. That's why the doctrine says that if it is an absurd result, and in this case, there's no other scenario. If any amount of money, it's not...
scenario, the statute doesn't apply. Just like would be the case in the common law if the statute didn't exist.
I understand, but we're dealing with the statute. So what would be the reason for the legislature? Let's go back to, what Judge Altenburn said, well, there might be a reason.
Yeah.
What would be the reason for the legislature to say, if you're awarded $1 and then you proceed, you're subject to sanctions, but if you're not, if you get 0, if you get the best...
The legislature says, listen, you got something in the non-binding arbitration, don't be greedy. If you don't do... if you come in less than 25% of that, if you continue to trial, you're going to get zapped for fees. But, the legislature, as Judge Altenburn pointed out, knows arbitration, the reason for the existence of arbitration is that it is a far more informal procedure. however formal or it might be, is far more informal than participating in a trial in a court, and we have a constitutional right to access to the court.
And you
get
still have
sent
your
for non-binding arbitration.
But that denies what the statute's about. The statute is designed to
But
put sanctions on
The
people.
statute is about what we can't take what the statute is about and go legislating from there. We have to take what the statute is about and see what remedy the legislature has given.
Unless you consider, as Judge Davis and Judge Sleet did, that it is an absurd, and I submit it is the most absurd result. The only result would reward somebody for getting 0 to let them roll the dice. Because in this case, do you think for a second that if the arbitrator had said, Patels, you're suing for over $1.5 million, I'm going to award $1. Even if he came out and said, the reason I'm awarding $1 is because there's a statute out there. Do you think that they would have said, you know what, we better not try it because we're going to then be subject to fees from this point forward? I don't think it would have chilled anything. And I think that that is the sole reason that the absurdity doctrine exists, is for situations like this when somebody gets the best possible result and somebody else then decides to roll the dice with complete impunity. I understand your argument. I'm just trying to give you the other side of the argument and what was persuasive to Chief Judge Davis and Judge Sleet in that case. I understand what you're saying. I just respectfully disagree and submit that the absurdity doctrine, that this is why it's created. I understand what the clear language of the statute says. It says what it says. There's no doubt about that. But I refuse to believe that the legislature consciously said, we have a situation where if somebody gets zipped, you know what, there's no sanctions or repercussions for them.
Except in every other circumstance where there's not a statute.
Except in every other, but I doubt the legislature was considering the American rule versus...
Well, that's why they enact the statute.
I think they enacted the statute.
They know there's an American rule. They are deemed to know that. And so that's why they enact attorney's fee statutes, because they know that otherwise there is no right to them.
This is a statute that was created to clear up the court systems, to have alternative dispute resolutions. In fact, I think that's the title of the statute if you look at it. But it clearly has a sanction in it. And the whole purpose of the sanction, you deny the sanction by saying in the worst possible scenario when somebody gets 0, there's no sanction. They get a free wheel to just roll the dice. I don't have anything else to add on that. I understand your argument. I respect your argument. I just respectfully disagree, Your Honor. Sure. Getting back to the first issue in this case, there's no doubt that there's a bright line 30-day rule, no doubt that it was missed in this case. I think the issue that we are here on, and the sole issue, is whether or not the trial court abused its discretion in this case in finding that there was excusable neglect. There was a clear waiver, and let me say that there are 4 reasons in this case that the court did it. One, at the hearing, we gave explanations. There's the 5th District Court case of Carter versus Lake County, which sets forth in this scenario what happens, and the court states that excusable neglect is in essence an equitable one which should take into account all of the relevant circumstances. And then it sets forth what those circumstances are: prejudice to the other party, the reason for the delay, the duration of the delay, and whether the movement acted in good faith. The court goes on to explain that this is a liberal standard to be applied when looking at excusable neglect. In this case, the trial court heard argument or evidence, however you want to say it, because counsel did not object at that point in time, arguments, evidence on all of those issues. He heard argument as to the reason for the delay. He heard argument as to whether there was prejudice to the other party. There can be no prejudice. We know, as stated at the evidentiary hearing, and I believe the transcript starts at record 1961, where we say that the day after or within 3 days, trial counsel for the Patels was sent an email saying we're moving for fees. So we know that they were aware, and if you look at the Florida Supreme Court of Ameris, it says that the reason for the change in Rule 1.525 was to prevent unfair surprise and prejudice. They can't claim unfair surprise and prejudice that we were seeking fees when they received an email telling them. In addition, these parties knew, and I'm not sure how much this panel is aware, These same parties, my clients, were sued in a binding arbitration, 2 non-binding arbitrations that were consolidated, 2 separate trials. We prevailed in all of those. There have now, this is the 4th appeal where the Patels have been the appellants. They have lost on every single issue that they ever sued my clients for. In the first case, they sued and fees were awarded against them. It went up on appeal, and the appellate court said we were the prevailing party. We won on that. The second case, it went up. That's the one where it was partly reversed because of Diamond Aircraft and then partly upheld. That one, they sued us for over $1.5 million, claiming fraud, breach of fiduciary duty. A 17-page order was entered against them on every single issue. Both non-binding arbitrations, the arbitrator found against them. They filed trial de novos. The third case was the one that we're here on now, where they sued us for over $800,000, separate allegations of breach of fiduciary duty and fraud, and there were 2 fee awards out of that case that they appealed both of those. The court considered all of this in terms of the issue about surprise to them notice. The court considered the relevant factors in good faith about that we filed a motion for enlargement of time when we lost about it. Judge Crenshaw, you raised a good point about, telling staff. It's the same difference. The issue in this case is the trial judge listened, and I would submit to you that the standard is whether or not a reasonable judge could differ. The trial judge weighed all of the factors in this case. He heard the explanation, he looked at the record, he looked at the motion. In fact, he even listened to trial counsel for the Patels, who, now claiming that there was no factual evidence, cited to our motion. Part of his argument was he was reciting back the grounds. The judge heard all of the arguments under both the case I just cited, Carter versus Lake County at 840 Southern 2nd, 1153, 5th DCA, and also the Boudat versus Boudat case, which is also out of the 5th DCA, follows the same scenario. If you look at the cases cited by the appellant in this case that talk about inadvertence or excusable neglect, all of those cases, when they talk about it, are situations where the attorney, for example, didn't file a motion for attorney's fees. They simply filed a notice of hearing. One of them is the attorney for 8 months they filed an amended complaint and they didn't serve anybody with the service of the summons and the amended complaint for 8 months. But significantly in all of the cases, the testimony was that the counsel had forgotten about the case or didn't know the law. There were statements from the counsel where they said, listen, I was confused between the difference between Rule 1.442 and Florida Statute 768.79 because one of them says 30 days. Another one is the situation where the attorney had a jury trial verdict was entered and they didn't do anything for 8 months, and the counsel said, well, I didn't realize that the rule applied. I thought it was when you got a final judgment as opposed to the jury trial verdict. That's not what we have here. We have testimony in front of the court that we knew about the rule. We knew about the rule because in this case, in this lawsuit, the other party that was on appeal, JVR&K, filed a motion for fees. In that case, we prepared that also. We knew about it from the prior case where we sought 2707. We knew about it because we sent an email to trial counsel telling him the grounds upon which we were filing and seeking fees, that there was a non-binding arbitration and you got 0 in both cases. So the court is best equipped, as Judge Northcutt said in the very first or second appeal today, we're not a court that hears new evidence. The trial court in this case heard the evidence, weighed the evidence, and I would submit, you can disagree, but it's not unreasonable for the trial judge to come to that conclusion. I don't believe there's anything else for me to add that's not in our briefs unless the panel has any additional questions. If not, thank you.
Mr. Saban. It's fun arguing with you.
No, I understand, Your Honor. Thank you again.
Because, Judge Davis does that too. Did he do that in the other case?
What's that?
Judge Davis argues with, never mind. Okay, you're up.
Okay, I just want to make a few points. The first point, the act regarding section 44.1036. and this is an obvious point, they say that it's absurd that they're not getting, that they're not going to be entitled to fees if a party goes from 0 in arbitration to 0 at trial de novo. But again, you're not normally entitled to fees. This is a sanction. There's no obligation. There's no common law to support their right to fees. This is a sanction, strictly construed. Again, there's lots of absurdity that we can come up with in this. It's absurd that you can get $100,000 at arbitration, go to trial and recover $80,000, do much worse, and the other side wouldn't be able to get fees in that situation, even though we're doing significantly worse. I mean, that's absurd too. The legislature has drawn the line. There's going to be absurd results no matter what, and they get to draw the line where they want to draw the line. Another point I'd like to make out, it's completely likely and probable that the legislature considered this scenario, this 0 to 0 scenario, because after all, it's probably one of the most common scenarios you're going to see under the statute. It's very easy for them to fix this. If this is a severe problem, send it back to the legislature, fine. But in terms of the court involving themselves, it's completely improper, especially in light of the statute being strictly construed. As to Rule 1.525, opposing counsel notes that there's these factors that are involved. Those are prejudice to us. That's fine. We're working outside of those factors because we're saying if it's an operational error, it's excusable neglect. If it's not an operational error, if it's an attorney mistake, it's not excusable neglect. We don't even need to go through those factors because we're saying you're on the side that says it's not excusable neglect. And the last point I want to make is not really relevant, but I keep seeing it over and over, and that's sort of this fairness doctrine. We're the bad guys, they're the good guys, so they should win. We didn't file all the cases. We filed this is a business breakup, a medical business breakup between two sets of doctors who have completely different business philosophies, and their business broke up. We sued initially. We lost. We did not appeal the loss on the merits. We appealed the attorney's fee award. We obtained a reversal on 2/3 of those fees, and then the other issue is the 44-1036 issue, which we feel is a strong issue. The second appeal was, and all the cases after that have dealt with their decision to form this side company, JVR&K, purchase the note and mortgage on the big building, which is a multi-million-dollar building, foreclose on the building, and then enforce the guarantee agreements against us. And they've also filed a malicious prosecution action against us, which was resolved in our favor on summary judgment, and they filed a separate action to essentially enforce the guarantees in their entirety against us. So, what's fair is the law in these cases, and we take a little bit of offense to being constantly painted as the bad guy. So with that, I will rest my case, and thank you for your time.
Thank you both very much.
Thank you.
With that, we're adjourned.